Up in the morning and out to school.
Indeed, it is up close and personal. And we're back. And we're back to talk about your financial situation, about your money, more importantly about your money and how to keep it, as we do here every week on CIL 650. And again, that's the name of the show, It's Your Money. And I think that's very significant, because the only way it's your money is if you don't spend it. Because once you spend your money, you don't have it anymore, and it's not your money anymore. So you have to control your spending if you want to have some money. So we're talking about how you can become financially independent sooner and stay financially independent longer. And that's by spending less than you earn and investing the difference wisely, and not having a deficit and running up a ton of debt, which is bad debt. The interest is high and it's not tax deductible. And at the end of the day, if you follow all the principles that we talk about on this show, you become financially independent. You become wealthy. And then there's still a final step, because the government taxes you on every cent that you earn, and then they tax you on your final tax return as well, and that's after you've gone. So we talk about how you can save all those taxes and how we can pass, by way of your legacy, those assets on to your beneficiaries, your children, your grandchildren, and everybody else down the line. Joining me today is Alfred Field. And Alfred is a lawyer who does estate planning. And we're going to talk today about gifting and the importance of gifting in the estate planning process. His statistics are up here on the screen. I'm not going to bother to read them to you. Maybe he can tell us who he is and what he does and everything else. So welcome, Alfred. Welcome to the show.
Thank you very much, Fred. It's a pleasure to see you again.
Mm-hmm.
I practice, I don't do nothing but estate planning, but I do a lot of estate planning and assisting people with respect to deciding what they want to do with their wealth that they've accumulated over time. And one of the difficulties that people are facing with their decision is, what is it they really want to do when they are transferring some asset to somebody else? And it really comes back to what their intentions are at the time, and frequently find it's not clear what they intended to do at the time. And that's the purpose of my being here today.
I have a client. Let me give you a case study. Maybe this is some free legal advice over the air or something. I don't know. But let's kind of make this a case study. I have a client who's in her 80s, and she has an investment with me on which she has an unrealized capital gain of somewhere around $300,000. Sizable amount. It's over $1 million. And she wants to give money to her grandchildren who are in their 40s for their education. So she just wants to give that money. Now, if she just gives that money, she has a tax problem, right? Because she's going to realize some capital gains on that portfolio when those shares are transferred. And there's no way that she has any control over whether those grandchildren spend that money or not. She wants to make sure it's for their education. So I'm just going to stop right there. What are her options, in your view?
Well, there's several options that she has with respect to her restrictions that she wants to place on the gift. One is she can provide in her will that the monies that are available are used expressly for a particular purpose, and have an executor and trustee make sure that that's how these proceeds are actually used. The second option that she has available to her is she can set up a trust, which would have similar restrictions placed upon the use of the proceeds, and have someone monitor that to make sure the proceeds are being used in a specific fashion.
But if she simply gifts the money to the children, she triggers tax and she has no control over it at all.
That's correct.
Okay? So she could take the money, she could buy segregated mutual funds, and she could name beneficiaries. That way it doesn't go to the children until she passes away. And remember, she's in her 80s. Okay? She could set up an inter vivos trust. How about an alter ego trust? Would that work?
An alter ego trust would work, because she is in fact over 65, so that's available to her, and no gain would be occur at that time.
Okay. Now, what about the cost of setting up a trust? What would a trust cost? This is not too complicated, I don't think, is it?
Well, no, it wouldn't be. An alter ego trust could cost $3,500 or more, depending on what she wants to do. And sometimes people have things they want to put into the trust that they're not sure about.
Well, she actually had a lawyer involved in this at one particular point, and she decided not to use the trust because the lawyer told her it would cost her $20,000. That to me would seem way out of line.
I don't have all the facts, Fred, to be able to comment about why the fee was there, so I don't think that.
Well, it's just a simple trust. Nothing too complicated. It's 10 mutual funds. That's it in a nutshell. So it's not very complicated.
We frequently find people think our matters are not complicated
I
until we delve
understand
into
that. Yeah,
them,
I
and
know.
then we find
Yeah,
out
I
that
know.
there's lots more complexities than what we anticipated.
But generally speaking, I think that a trust, and I used to set up lots of trusts for clients, should cost somewhere around $2,000 to $3,000. So what you said would be ballpark most of the time. And again, I'm not trying to put words into your mouth.
A lot of circumstances.
I'm not trying to lead you there.
As I say, it varies and it depends on the circumstances and the complexity. So it's hard to comment.
So gifting money is one way to, gifting money while you're alive is one way to avoid probate. Because if the assets stay as they are in the client's name until such time as they pass away and there's no beneficiary and there's no joint owners, that triggers probate, and probate in BC is about 1.4%. Am I correct?
That's
in
correct.
saying that?
Yes, probate fees are quite expensive.
Okay. So one of the ways to avoid probate is to gift. So let's expand on the gifting process. So you got free reign. We can talk a lot about it.
Okay. The gifting process seems somewhat simple, but fundamentally there's the person who wants to give the gift, and they identify the person to receive the gift, and the gift is offered, I guess, to the person. The person must accept the actual gift itself. Okay. And one of the simple examples I can give is I offer Fred a cup of coffee, thinking I'm being a kind person, and unbeknownst to me, Fred drinks tea. And so I said, "Here, Fred, here's a cup of coffee for you." And Fred politely says, "Oh, I'm sorry, I only drink tea." And so Fred has, in this instance, decided that he's not going to accept the gift that I offered to Fred. So a gift must be accepted.
So if I decide to give my boat to my son in the event of my death, or no, pardon me, while I'm still alive, I should say, if I decide to give my boat to my son, he has to accept it.
That's correct.
Okay. And if he doesn't accept it, what happens?
It remains your possession and your asset.
And it becomes an asset which will be subject to probate in the event of my passing away.
In the event of your passing away, it would then be distributed in accordance with your will, if you have one, or if you don't, rules of intestacy.
And that could apply to my house, it could apply to my car, it could apply to anything I own. My Rolex watch, doesn't matter.
That's correct.
Okay.
Now, gifting actually became, we had a number of presumptions that we faced when gifts were provided, and there was a case recently that dealt with gifts and how they were dealt with, and they divided the asset between a title or legal ownership of the asset and the interest in the asset. And people customarily have bank accounts that they set up, and they want to retain the right to use the funds, they want to retain the right to ownership, but upon their death they want the actual account, bank account, to go to a particular beneficiary. And those actually are fraught with a lot of difficulties. And there's the legal ownership, who actually has the account. People frequently set up what they think of as a joint account, but they don't want people to withdraw funds. So the first part is who actually owns the account. The second part is who's entitled to withdraw funds from the account. And the third thing is what happens to the account at the time of the person's death. And that was analyzed quite extensively by the courts and continues to be analyzed by the courts as to what the intention of the individuals is at the time they set up the account.
If I have a mutual fund registered jointly with my wife, myself and my wife are joint owners, can I sell that fund just on the strength of my signature, or do I need my wife's signature too?
It depends on the nature of how the account was set up, but customarily one signature would be all that would be necessary to sell the mutual fund.
So you don't need the signature of both joint owners all the time then?
That's correct.
Okay. So I suppose if the account was set up so that it was and or rather than myself and my wife, you'd be able to do that, right?
That's correct.
Okay. So gifting, you got to really be very careful, and there's been some changes in legislation in this area, have there not?
There has been. In the new statute that we're dealing with for estate matters, the Wills, Estate and Succession Act, which we loosely refer to as WESA, has changed the burden of who needs to prove that the gift was made and the intention of the individual. So the burden is now shifted to the recipient of the gift in some circumstances, and that person then has to show that they're not holding the asset for the benefit of the person who transferred that interest to them. They actually have the right to the asset itself.
Okay, so you're on the practice advisory panel for the Wills and Estates and Trusts, and a former member of the board of variance for the city of Burnaby. You're a former member of the discipline body and past president of the Burnaby Minor Hockey Association. So you got some pretty strong credentials.
I have some very practice and interest in whatever. I was on the Nurses Association. I was a public member for their review panel as well.
So you really know what you're talking about.
I hope so.
So listeners, and so if you just tuned in, I'm certified financial planner Fred Snyder. I'm sitting here talking to Alfred Field, who's a specialist in estate planning and really subspecializing in gifting. That's where he's at right now. And maybe you have some questions involving your situation and circumstances. Maybe you want to make sure that you have some control over your assets. Maybe you're unsure of how you should go about the process of estate planning. Maybe there's lots of questions on your mind. Maybe you don't have an up-to-date will. Maybe you have a will, but you're not sure that it should be revised or looked at again. And again, I emphasize the fact there has been some serious changes called WESA in estate planning law. We used to have the Wills Variation Act here in BC. That's been a big stumbling block for a lot of people. I want to talk about that and much, much more. But I want to have conversations with you, our listeners. So if you're listening to the show and you just tuned in, give us a call. You can reach us right now at area code 604-280-0650. If you're calling long distance, it's 1-877-280-0650. You can log on if you want to see what we look like. You can log on www.cisl650.com. Now, there are those who've told me many times, I'd love to call the show, but I'm shy. I'm reluctant to talk on the air. Too many people listening, but I would really like to get in touch with you. Well, that's easy because I have Frida just for your convenience down at the office right now. You can reach her at 604-737-3512. If you're calling long distance, it's 1-800-661-1495. And for your information, I'm going to be in Nanaimo on Tuesday, so if you're over on the island, you want to have a visit with me again, call Frida and book an appointment. I'll be staying at the Coast Bastion Hotel. So once again, if you just tuned in, I'm certified financial planner Fred Snyder, also a registered financial planner. I represent Scotia McLeod, and my mission is to teach people what they need to know to make better financial decisions, and that's what we're doing right now here on this show. So get a pencil, get a paper, take notes, because whatever you write down is what you retain from this show. Maybe you have a question. Let's talk about it. Get on the line and give us a call. So Alfred, in your practice, when you do the things that you do, what's the worst thing you've ever seen? What's the worst mistake that people can make when it comes to gifting?
Really, they don't document what it is that they're doing. That's fundamentally the biggest difficulty that we face. In smaller sums of money, it's not usually an issue. But when people give larger sums of money, they don't really make it clear under what basis the funds are being given to the individual, whether it's a loan, whether it's really a gift, whether they're to account for it when the estate is distributed and say, well, one child got more than the other, so they should account for the larger amount they got in advance of the death of the parent. Those are the problems that we face frequently, and there's lots of dissension with the other beneficiaries when they discover oftentimes that this is happening.
You must see a lot of this.
We do see a lot of that, and it's quite unfortunate.
A lot of strife because things weren't well spelled out ahead of time.
And people are just, again, they're looking back, and sometimes the person who is a primary caregiver has got the burden, and the other people are not interested or don't want to interfere, and then at the time of the death of the individual, they start asking the questions that they would have liked to have asked earlier but chose not to.
I had a lady in my office last week, actually a husband and wife, but he had two stock certificates that were worth somewhere around $120,000. Wants to sell them. I said, how long have you had these stocks? He said, maybe 25 years. So I said, what'd you pay for them? Don't have the foggiest idea. Would he have a problem? He's got a big capital gain problem. Right?
A big capital gain problem to find out what the value of the stock was when he acquired it.
Let's talk about that problem, because that's fundamental to almost everything that we're talking about. What's the adjusted cost base? What's the fair market value today? What's the capital gain? So how can he fix it, first of all? Is there a way he can figure it out?
He can go back and get historical information as to what the average price was at the date that he acquired the stock. It makes it more difficult if he received dividend income in the way of a stock dividend.
These are drips, so the dividends go back in to buy more shares.
Yeah,
and
and
make
so
it
there's
more complicated.
have to trace those through as it goes through, and it's a real struggle to determine what that would account to.
So what position would CRA take? If he sold these stocks and he's trying to establish the cost base, what position would CRA take?
My experience has been that if you have reasonable information as to how you came to the value, they will frequently accept that. Not always, and it's up to you to determine what the cost is.
So the burden of proof is entirely on the taxpayer?
It's on the taxpayer. The taxpayer is the one that's going to have to go and show that these are the actual cost base for these shares.
Alfred, let's take a call. She's been waiting a long time. Let's talk to Elaine from Burnaby. Elaine, welcome to the program.
Hi, good morning.
Thanks for waiting, Elaine.
Yeah, that's okay. Yeah. I just want to find out, is there any tax implications if I decided to give my son a sum of money to pay off his mortgage?
Depends on the source of the money. Are you talking about, is there a gift tax? And the answer is there is no gift tax.
There is no.
There is no gift tax. But if the money comes from something that has a capital gain attached to it, then there is a tax concern. When I say tax, I'm talking about income taxes.
But if it were to come out of her bank account, there'd be no tax.
There's no taxes.
Because if let's say you gave him $100,000, to have $100,000 in your bank account, you already paid the tax on it when you earned it.
Yes. Yeah.
So it's not double taxation. But if you sold a mutual fund or some stock or some asset, and that triggered a capital gain, you'd have to pay the tax on the capital gain. So Alfred's right. It depends on where the money comes from.
So how about my principal residence? If I die, and if he sells it, then will there be any tax on it?
Well, if you pass away, the principal residence is tax-free at that point. Now, if he already has a principal residence and he inherits your house, only one of them can be the principal residence. So it depends on which one it is. You might want to answer that.
Yeah, no, Fred's correct. Your principal residence would be tax exempt at the time of your passing, and there's no income taxes charged to your principal residence at the time of your passing.
There's two things, in my view, Elaine, that everybody should have. They should have a TFSA, and they should own their own house, because they're both tax-free. That's the best tax savings of all. Something you never pay any tax on whatsoever. RRSP is just deferred tax, okay? TFSA is absolutely tax-free, so is your house. If you tripled your money in a TFSA and then sold it out, you wouldn't pay a nickel in tax, not 5 cents. So for all of our listeners out there, if you're listening to the show, what you should be doing, if it makes sense, is to be making maximum deposits to your RRSP, and then taking the tax that you save on the RRSP and putting that into your TFSA. Don't spend it. Okay, so for example, if you made a $10,000 RRSP contribution and you save $4,000 in tax, if you spend the $4,000 on a cruise or something, you really only put $6,000 into the RRSP. But if you start with 10 You get 6 into, you put the 10 into an RSP, you get a tax refund of 6. That 6 goes into the TFSA. Now you've really invested $10,000.
So tax-free savings account,
Yes.
if I die, he'll just get it, right?
There's a benefit. You can name a beneficiary on a TFSA as well.
Yeah. Okay.
And
Thank you.
again, if you, anytime you can name a beneficiary or own things jointly with rights of survivorship, it goes around the estate. It doesn't go through the estate and avoids probate.
Okay.
So everybody should gift money, as Alfred is saying, to reduce the estate. Give it away while you're alive, but be careful how you do it. Name beneficiaries wherever possible. You can buy segregated mutual funds. These are insurance products. If, let's say you got $400,000 in a bank account, you pass away, that goes into your estate and that's owned jointly. But you could take that $400,000 and buy a life insurance segregated fund where you can name a beneficiary. Then it bypasses your estate again. So wherever possible, you try to bypass your estate. Does that make sense, Alfred?
It makes sense from a probate point of view, absolutely.
Yeah. Okay. So you know, there's no really cookie cutter answers to what we're talking about. You need to sit down with a financial advisor and fine tune everything that we're talking about. Have it set up so that it applies directly to you. That's what we're dealing with here. Okay.
Okay. Thank you.
Elaine, I hope that answers your question. And if you have any more, give us a call anytime. Take care. So if you just tuned in, I'm certified financial planner Fred Snyder. I'm talking here with Alfred Field. We're talking about gifting and as it ties into estate planning. We're taking your calls. Remind you once again, this is a live show. Tomorrow there'll be a replay between 10 and 11. But for those who are shy or reluctant to talk on the air, you want to make an appointment to see myself for a second opinion on your investment portfolio. You want to get a written financial plan. Give Frida a call. She's down at the office right now. Area code 604-280-0650. Long distance 1-877-280-0650. And, you know, we try to talk a bit on this show about the issue of motivation. Motivation. It's a very, very key issue because the reason, I really think the main reason people fail financially is they don't want to succeed. They don't want to pay the price. Okay? They're not motivated. So how do you motivate yourself? You motivate yourself with affirmations. You motivate yourself by realizing that you can't keep on procrastinating. It's time to do something. It's time to become proactive about your financial situation. And I don't care if you're just starting out. I don't care if you're halfway there. I don't care if you're already there. And I don't care if you're near death. I guess I do in a way. But the bottom line is you have to do something. So if you're near death or you're worried about your estate, it's time to make a phone call. Time to get yourself a financial plan. So give us a call, 604-280-0650. Long distance, 877-280-0650. Log on, www.cisl650.com. And Frida, for your convenience, is down at the office, 604-737-3512. That's the most important number of all. If you want to make something happen, give her a call. If you want clarification, give us a call. Once again, our number here is area code 604-280-0650. We want to talk to you. We want to have a conversation about your money and how to keep it, how to make sure that your legacy ensures that your descendants keep the money as well. So, Alfred, the financial planning process involves a number of steps. And the second last step is your legacy or your estate plan. And the last step is how frequently you should review everything. So if somebody has a proper estate plan and they have a proper will, how frequently should they review that?
We recommend that they review it at least once every 5 years. 3 years is certainly preferable. And of course, if there's any major changes in their lives,
as there has been with WESA.
Well, now would be a good time to have a look at their estate plan and see if their will. If you did a will prior to WESA, the will is valid and will carry out your wishes with respect to that. Certainly, it's an opportune time to have a look to see if WESA impacts your personal matter and whether it's appropriate to do a new or update your estate plan. That legislation, of course, is a major impact, and it would be a good thing to do. We also have changes with the Family Law Act, so that's something else that people might consider how it impacts their estate planning.
So, for example, if you pass away without a will and you leave a spouse behind, what happens?
The distribution of the estate is governed by the intestacy rules under WESA. They are different than what they were prior to the introduction of WESA. If you have a surviving spouse, we'll say for the present case there are no children, then your estate would go to your surviving spouse. If there are children, then there are different rules under WESA. I'm not as familiar with them as I was. The spouse, in the usual circumstances, gets the first $300,000, and then the estate is divided between the spouse and the children.
Okay, what about the house, the matrimonial home?
The matrimonial home, the spouse has the right to, it's almost like an option to acquire the house.
Okay.
It doesn't automatically go to the spouse in that sense. They have an option to acquire it, and the court can determine the terms of how that's going to happen.
The court would determine the price, or is it fair market value?
The determination is by agreement between the parties, unless the spouse is the executor. If the spouse is the executor, then the spouse can go and go to the court and get approval for the number that they've decided upon with respect to that. Now, I'm speaking somewhat concerning the general distribution rules, and I'm not 100% sure whether the rule pertaining to the house applies to an intestacy as well. I believe it does, but I'm not 100% sure. But it's dramatically different than what it used to be.
So I think, I think the summary, essentially is the fact that there's been major changes, and anytime there's a material change in anything, it's time to take a fresh look at it. Does that make a lot of sense?
That makes a lot of sense.
So that's the issue. So again, I'm gonna take a call, and then I'm gonna kind of branch off for a minute. I just want to talk about a few other things. But let's talk to Jane from Comox. Jane, welcome to the program.
Good morning.
Hi, Jane. How you doing?
I'm doing okay. I'm just turning the radio down. It's
Okay.
Jean, Jean. Anyway, I'm doing fine, getting ready to leave for Mexico, but I have a
Well, congratulations.
fairly simple question.
Okay.
I've made up my own will, and I've had it checked, but I did put in gifting for grandchildren, all of them mature grandchildren. Can I just write that in the will, or do I have to find some devious method to give it to
Some
them?
devious method?
Are you talking about you want to make a gift
I'm
at
going
your
to
death,
make a gift to each grandchild.
but it's not presently in your will?
Well, I put it in my will, but I'm wondering, from what I'm hearing on the radio here, that maybe I shouldn't be doing that.
No, there's no reason not to. It depends on what you want to do.
I just want to give them a gift to have something nice to remember me by, and maybe take a cruise.
Okay, so there's no reason to change your will to provide a gift today that you're mentioning. So I don't. You're not indicating to me that there's any reason to change the provision you presently have.
Good. I did have a provision to gift a little bit to each great-grandchild, but I was told that it wasn't really a good idea at my age. Maybe I would have to make trusts for each child. So that's too much trouble and too much expense for the little bit that I was going to give.
If the great-grandchildren are minors, it does create some administrative challenges and difficulties.
That's what I was told. So.
Yes.
But it's just a simple gift for each grandchild who is able to manage their own finances.
Okay.
Yeah, so it's okay to leave that in there?
Absolutely. One of the reasons you would give a gift in advance of a will, so you give a gift today, for example, is to reduce the size of your estate, so any probate fees that would apply to the administration of the estate would be reduced because the gift had already been given away. So it depends on your circumstances whether In the meantime, you may need the money, and if you've given the money away in advance, then you don't have that available for your present needs. So.
Right. Well, I think I'm going to be okay the way I am. So, thank you for that information.
Gene, appreciate your contribution to the show.
And let them enjoy the gift when it comes.
And I'll tell you, one of the things that we'll do for you and all people who call the show, I have some will kits. They're worth about $30 each. I'll be happy to send you a will kit because you called the show.
Well, I've already got it pretty much set up and had it.
Well, this already explains all the issues that we're talking about.
Simple.
So if you want the book, all you got to do is touch base with Frida. So give Frida a call down at the office. You can reach her there right now. Area code 604-737-3512.
Okay.
Appreciate the call.
Thank you very much for your time.
Okay, thanks, Gene.
Bye-bye.
Bye-bye. Now, Gene's line is now open, so if you just joined us, ladies and gentlemen, listeners out there, I'm certified financial planner Fred Snyder, also registered financial planner. We're talking about estate planning and all the issues that are involved, and one of them certainly is gifting. And I have Alfred Field here, and Alfred Field is a lawyer in that particular area. That's what he specializes in. So if you have any questions regarding gifting, he's the man to talk to. What I want to do is I just want to click on this will kit issue. I hope my internet connection is working properly here today. But this is what I'm talking about. So if you give the show a call, we'll be happy to give you compliments of myself a will kit. It's a book. It explains how to do your will, and there's a instruction form in there that you just fill the instructions in before you sit down with your lawyer, and that will all work out. But my internet connection doesn't seem to be working, and I probably just messed my computer up big time here now too. That's the trouble with all this modern technology. You can't even close it. I'm really in trouble. But anyway, the bottom line is I can get along without it. Number to call, area code 604-737-3512, 604-737-3512. You want to talk to Frida, she's down at the office right now. And if you want to make an appointment to see myself for a second opinion on your investment portfolio, give her a call. Everybody gets worried about the market and everything that's going on. Let's see if this one works this time. That looks like it's going to work. There we go. Don't pay too much attention to the media. I mean, there's lots of bad news out there right now. Jumps right out and bites you, okay? I mean, look at this. It's a gloomy moment in the history of our country. How about the history of the world? Would you not agree? I think you would. The domestic economic situation is in chaos. Look at the price of energy. Who would have foresaw this happening? Our dollar is weak throughout the world. We're talking about a Canadian dollar less than 80 cents right now. Prices are so high as to be utterly impossible. Anybody out there think the cost of living is going down? The political cauldron seethes and bubbles with uncertainty. Russia, Kim Jong-un, South America, all over the place. Russia hangs as usual like a cloud, dark and silent upon the horizon. It's a solemn moment of our troubles. No man can see the end. That was in Harper's Magazine, 1847. So the question is, ladies and gentlemen, what's new? Not much. We have our struggles. We have our challenges, certainly. We have to deal with them. But that's the bottom line, and it is definitely a gloomy moment in history. Let's see if this one works. Newborn baby, only 22,463 days left until retirement. Now, I don't imagine there's too many newborn babies watching this show or listening to this show right now. So where are you on the timeline? That's the average life expectancy of people today. 22,463 days. So how wisely are you going to use that time? Are you going to start in the accumulation process right now? Are you going to get yourself a proper financial plan? Are you going to make sure that you have the best investments inside your investment plan? And at the end of the day, if you're successful, are you going to make sure those assets are passed along to your beneficiaries without stress, without them fighting over it, without the government grabbing it all in taxes? These are all very, very important issues. There's one more thing I want to do before we get back to Alfred. and it's right here. I hope this one works. I brought my portable internet connection, and it's supposed to be working. Looks like that works too. Wow, I'm laughing. So these are all, this is one of my workshops. That's the agenda of one of my workshops, and it's on your legacy. And this is workshop number 13. And these are all the issues that you need to deal with, your body, your organs, your funeral, etc., etc. I can go on and on. I could spend the whole day talking about everything that's on this particular agenda. I don't want to do that, but I want to do this. I want to say, who did the best job at preserving wealth? Okay? Alwyn Ernst of the accounting firm Ernst & Ernst. Elvis Presley. Charles Woolworth. Lawrence Wien. Henry Kaiser. Henry J. Kaiser Jr. Who did the best job? Well, here's Elvis. Elvis Presley, when he died, left an estate of $10 million and lost $7.3 million of that to the tax man. Charles Woolworth lost $10.3 million, or 62% of his estate, to the tax man. Lawrence Wien lost $22.5 million, or 61% to the tax man. Alwyn Ernst lost $7 million to taxes and costs, or 56%. Henry J. Kaiser lost $2.4 million, or 44%. Henry J. Kaiser Jr. only lost 2%. So estate planning does work, ladies and gentlemen, listeners out there. And again, give us a call. We're talking about your money, more importantly about your money and how to keep it. Don't go away. We'll be right back after this break.
Fred Snyder.
I want people to call the show that are genuinely interested in increasing their financial IQ so that they can become financially independent sooner and stay financially independent longer.
Fred Snyder.
You don't have a blueprint. Imagine trying to build a house without a blueprint. And how about having a blueprint for your life? What are your lifestyle goals? You need to think about your family life. What are your goals about your family life? What are your lifestyle goals when it comes to health? What are your lifestyle goals when it comes to finances, mental and spiritual? You have to set goals in all those areas, not just finances.
Fred Snyder.
Often we fail because we put too much emphasis on one area and ignore everything else. We work our butts off and we ruin our health. So life is all about balance. So you need a life plan.
Fred Snyder.
Napoleon Hill says this, wrote the book Think and Grow Rich. Anything that you can vividly imagine, ardently desire, and enthusiastically act upon will inevitably come to pass.
Fred Snyder.
My goal, my mission is to help people enhance their financial IQs by teaching them what they need to know to make better financial decisions.
Fred Snyder, Saturday mornings at 8 and Sunday mornings at 10 on Smooth and Easy, CIL 650. This is CISL Vancouver, Smooth and Easy, CIL 650. Welcome back to It's Your Money on CIL 650. If you have a question for Fred, call 604-280-0650. Now, back to Fred.
Okay, ladies and gentlemen, we're back, we're live, we're interactive. Remind you once again, we're talking about your money, how to keep it. And we're expanding on that a little bit. We're saying this is how you keep it. We're also now saying this is how you hand it down the line. This is how you pass your money on to your beneficiaries after you've left this wonderful world. I have an offer. Everybody who calls the show will get a free will kit, and I just was able to get onto the webpage right now. This is the Canadian Legal Will Kit. It's a free download. I can either download it. We have some hard copies at the office, or I can give you the link. It doesn't cost a nickel, and you got all kinds of documents that are at your fingertips right now, last will and testament, and so on. Not going to spend a lot of time there. Don't want to do that. I want to preserve our time to talk to our expert that we have here to talk to you and answer your questions regarding gifting, regarding your will, and regarding estate planning in general. I also want to talk about enduring powers of attorney, and I want to talk about the Wills Variation Act, and I want to talk about the representation agreement and what they are, and maybe expand a little bit more on the trust issue and the various types of trusts that are out there. A testamentary trust is the one that exists after you die. Okay, you got inter vivos and you got alter ego that exists before you pass away. There's the will kit that we're offering right now. You give the show. final wishes and instructions. You should fill that out before you go to your lawyer. That keeps the bill down. Maybe that doesn't help you, Alfred, but
It's actually very helpful because a lot of time is spent where people are thinking about things that they can think about prior to visiting to see us.
it helps you focus.
Yes, and it helps to focus on what's happening. We want to know what assets they own and what obligations they have and who they want to receive the proceeds, who else is involved in the family, and things of that sort. So keeping focus is always a very helpful matter.
So I assume that our listeners can see that. Dwayne, can our listeners? I don't know. You can't hear. It doesn't matter. I don't know if he blows that up big time when what goes on the webcast. Can our listeners see that whole screen, Dwayne? No. Okay. No way to do it. That's okay. Okay. So again, we're talking about your money. We're talking about your money, how to keep it, and we're talking about gifting, and we're talking to a specialist in that particular area, Alfred Field. So what are your questions? You may have some legal questions of one kind or another that you want to ask Alfred. So give us a call. And again, best case scenario, you get yourself a Canadian will kit by making that call. Let's talk to Debbie from Surrey. Debbie, welcome to the program.
Good morning.
Good morning, Debbie. How you doing?
I'm doing fine, thanks. I just have my husband and I have been talking about doing wills and everything. We've been talking with our kids, and they're both grown, married. And they keep going, oh, they're putting it off. But we're telling, I don't know if this is legal or not, we want to know, can they at least just write things out and put the way they want it and have it witnessed? Is that still legal if they don't go through, like, lawyers and everything? Can they still do it that way?
It's not a case of still, it's something that they've introduced under WESA that you can have a will document that can take all kinds of different forms. And so they could write out their document and sign it and dispose of their estate, and that could be admitted to court as a will document. It causes some difficulties and problems, and there would need to be court approval of the document that's being introduced to the court, but it could be considered the final will.
It could be, okay.
I'm always hesitant to suggest that be the ultimate solution, because I've seen documents that people have drafted and they miss things out, they don't dispose of their entire estate, and they sometimes create more problems than what they solve.
Okay.
So,
what should a will cost?
Well, it depends on the will, and people ask this frequently.
Simple will.
Well, everybody thinks they're rather simple. I hear that frequently. They say, oh, I've got a simple circumstance.
Yeah.
One of the things when people start talking about their will, their wills have pluses and minuses. And the pluses, you can do anything in a will that you could ever imagine. That's also the minus, because there's so many different opportunities that you can choose for your will, and the more things that you have in your will and the more things that you have that are different and distinct, the higher the cost would be to draft the document. So keeping it simple has its merits.
Can you give me a range?
Well, it's really hard, Fred, because you say, well, what is it I have to do? And then blended families cause higher expenses because there's more consideration. When I'm talking about blended families, I'm talking about somebody who's had a prior marriage or relationship, and so they got one or more multiple spouses or former spouses to consider. And those tend to be more complicated and also more expensive to deal with. The variation in cost of wills is quite high, and so the cost could be on the lower side in the $350 to $500 range, and they can go substantially higher than that depending on the circumstances, the person's assets, what they're trying to deal with.
But in the long run, not having a will is even more expensive.
It can be lots more expensive as you go to court to try and figure out what to do and how to deal with the estate.
So it's like the old saying, you pay me now or you pay me later.
That's correct.
Okay.
And one of the things if you don't have a will, you're going to be faced with going to court because no one has any authority to deal with the estate except through court order.
And that involves the public trustee and everything.
Well, not necessarily a public trustee, but it could involve the public trustee being more involved than what you might like them to be.
Good.
Okay, we have to move along, Debbie, so we'll make sure you get yourself a will kit. Appreciate the call.
Okay, thank you very much.
You
for your
enjoy the
help.
rest of the weekend. Take care.
Okay, have a nice weekend.
You
Bye-bye.
too. Let's talk to Harry from Langley. Harry, welcome to the program.
Yeah, thanks very much. It's more of a comment than it is a question. And I just retired from about 4 years ago from a job, and I've got a good pension from it. And I went to work for a local university, so I'm, amassing another pension. But I just wanted to say to you guys, I'm really appreciative of what you're doing, because I don't have a will. I have a wife. I have 4 children. We just sort of seem to go along day after day after day thinking that nothing's going to happen and procrastinating and, like you say, not motivated. And the show that you've got, that you're putting on there, has really made me stop to realize that it's almost selfish of me not to go in and to pursue this will. And I just wanted to say thanks, because after listening today especially, and I do listen usually every Saturday, it just brought it together that I really have to start doing something. And so whether you get a lot of comments about how much the little guy appreciates what you're saying, I really do. And I think there's a lot of people out there just like myself that we're busy, we're thinking it's never going to happen to us, but you're making us realize that every time you're on the show that we've got to get our ducks in line. So I just want to say thanks. I appreciate it.
Harry, I can't tell how much I appreciate your comments. I need a pat in the back every now and then, and you're telling me the message is being heard, and that's the key to the whole thing. I'm not just talking to myself.
Yeah, it is being heard, and it makes a lot of sense. And we get tied up, like I say, we get caught up in the daily activities of our lives, and we seem to forget about the important things. And we're not going to be around to straighten out the mess once we go. And you're making it very clear that if we don't do it now, there is going to be a mess, and it's not fair to our loved ones that we're leaving behind. So I just appreciate it. And like I said, next week, a will is the first thing that I'm going to sit down with my wife, and we're going to find a lawyer here in Langley that we can put one through, or if you can recommend somebody will off the air. I'd really appreciate it.
I have one right here.
Not in Langley, unfortunately, but that's great. I'm glad that you're doing it, and please proceed expeditiously. And I think you'll find that just having that plan available and done will take some stress out of your life, actually.
Well, it's that and a financial plan, because I seem to, even though I've got a great pension from one job, I'm working at another job and I don't seem to have any more money. So obviously, I have to sit down and talk to somebody about a little bit of my financial plan.
Well, you can start that process, Harry, by giving Frida a call. You can reach Frida right now. Area code 604-737-3512. 604-737-3512.
I've got that number. I talked with the secretary just a couple minutes ago to get this number. So appreciate that. And I just want to let you know that you might not be getting the calls, but you're definitely making all of us think that we've got to move ahead. And it's very important what you do, and I really appreciate it. Just wanted to say that. Thanks.
Harry, you have a great weekend. Thanks for your call.
Thanks very much. You guys too.
Bye-bye.
Okay, bye-bye.
God, I wish I could get more calls like that. Because that's really the message, and he's hearing it, know. And I wonder how many thousands of people listening to this show right now are in exactly the same position.
The number of people who die from the probate office point of view without wills is very high. I can't remember the statistic, but it's a lot higher than I ever anticipated.
Well, the fact is that everybody's got a will. You got the will that you write, or you got the one the government writes for you if you don't have one.
Yes.
It's the same thing, isn't it?
Well,
so would you rather have the government write your will, or would you rather write your own will? Okay? And then don't write your own will without help, without a lawyer or somebody like myself to guide you and help you in the process. That's what we're talking about. And we also want to talk about, before we run out of time, we want to talk about the enduring power of attorney, and we want to talk about the representation agreement. These are two important issues that people get confused about. Okay? The difference between an alter ego trust and an inter vivos trust. Two more issues that we need to explain. But in the meantime, we'll talk to Maria from Vancouver. Maria, welcome to the program.
Hi.
Hi, Maria. How you doing?
I'm doing terrific. And The reason I'm calling in is because if I hear something and if I think of anything I can add, I pick up the phone, and I wish people would do that and not be afraid of you or anything else.
I don't
And
bite.
who cares who's listening? If you're going to educate somebody with your problem, isn't it worth it? But this is why I'm calling. I've always heard that a will should be updated, and I'm not sure of the timeline. I'm not sure how often, and I'm sure a lot of people out there are in the same position as me, so I would like to know. I did another will. I think it's the third time I do one, and I think I've got at least another 20 years before I go in the ground. I would like to know when should I redo the will, update everything in case there's a change, in case something is not the way it used to be.
Well, the answer is, first of all, looking at your will isn't needing to necessarily change the will. If your circumstances are the same as they were when you did the will, there's no reason to change the will. Sometimes people see addresses in wills and they think, oh, I'll change the will because the address has changed, and there's no need to change a will just because somebody's address has changed. What I say to people is, please don't write on the will, please don't unstaple the will. It causes all kinds of difficulties and problems. However, if there's a change of address, you can use a sticky tag and write an address, updated address on it. Looking at the will to see if an update is necessary. I mentioned previously 3 to 5 years is a good range to say, well, let's look at the will to see if it's still accomplishing the goals that I want it to accomplish. If it's not, it's time to do the will. Similarly, if you've had a change in circumstances, if somebody has died, somebody's got divorced, somebody's become incapacitated, you might want to change your will to provide them with nothing more or less, or some other change with respect to it. So those are the times that you actually look at the will, but it's not easy to give you sort of a time frame and say, well, you should change your will every 5 years. A change may not be necessary, but looking at it would be a good thing to do in the 3 to 5 year range as a minimum.
Okay, this is just an example. I am not doing it, and I don't want anybody that recognizes my voice or who knows who I am to run to my children. But my notary told me that when you do a will, you have to give 50-50 regardless of what's going on. Like I said, it's an example. I don't want anybody running to my children and saying, guess what, you're only getting 10%. So is this true? Is this the way it goes? Because I know families where the girl did everything and the 3 boys did nothing after they got married. So the girl got everything and the boys were upset. And
Maria,
my notary told me, no, it's 50-50.
If I can focus your question a little more, I think what you're asking is, can you discriminate with the beneficiaries, which means can you give more to one beneficiary than another? Is that correct?
Well, I'm asking, is it true? Is this the way it's done? You have to give equal amount? Because I know people that did not get equal.
It's an awesome question.
Okay. This leads into the question that Fred has asked, and that's the Wills Variation Act. What the Wills Variation Act has been put into the WESA, so we still have the Wills Variation provisions in WESA. And when somebody is doing a will, they have certain statutory obligations to a spouse and to children. If there is no spouse, then they have a statutory obligation to provide, and the term that's used, adequate provision for the children. It isn't necessarily 50-50. And there are circumstances where one particular child may need more money than the other because of their economic circumstances, their health, and a number of other reasons. There are circumstances where somebody is taken out of a will because of their behavior. That's a little bit more difficult to justify. And they, if you're planning on making a sort of a drastic change as to who's going to get how much, you really need guidance as to what would be appropriate concerning that amount. So do you have to give 50-50? It's not written in the statute that 50-50 is appropriate. That may not be enough for one child over the other. And
but when we use 50-50, we're talking about 2 children?
I'm assuming 2 children,
So
yes.
if there were 3, it'd be a third, a third, and a third.
Third and third and third. And of course, that's what people lean towards because they think that may be viewed as being fair. It may not, in fact, be fair.
You know, I'm glad I phoned in because whatever I do is my decision. And I'm saying for the third time, whoever you are, do not go to my children because some people that I know listen in, and then it comes back to me. I phone in because I enjoy doing it, but I wish the troublemakers would keep their mouth shut because Fred is not on the program to cause trouble, and I am not phoning in to cause trouble, but I'm being very honest. So
Maria,
that's why I said this is an example.
Appreciate your call, Maria. We have to move along because we're running out of time, and I got two more things I need clarified by Alfred while he's here, or we have to sign off. So I got to be gone in about 3 minutes. So we got 3 minutes.
Okay.
I want to know the difference between an inter vivos and a alter ego trust.
An alter ego trust is, in fact, an inter vivos trust. It's just that an alter ego trust is expressly available to people who are 65 years of age or older. One of the advantages of an alter ego trust is there's no capital gains triggered in transferring assets from the individual into the alter ego trust.
Okay, and well, let's take a call first. Let's talk to Ken from Surrey. Ken, welcome to the program.
Yes, hello.
Hi, Ken. We got to go fast.
Okay, well, I need a will kit because everything is starting to come to.
Okay, we'll see you get one.
My dad and my brother's will. Now I need to do it for ourselves.
Okay. Any question?
Well, there's all these things that you reminded me of that I did for my other family member 10 years ago. I need to get up to date and what's going on, and I reverse mortgages and all this other stuff.
Okay. All righty, Ken. I can't tell you how much I appreciate your call. We'll see you get the will kit, and if you want a second opinion on your investment portfolio, a written financial plan, see it at our next workshop. Give free to call.
I'm going to come and see you too.
Okay. Appreciate the call. You take care. Bye. Okay. Next question. Let's see. What was the next question?
Enduring power of attorney.
Enduring power of attorney and representation agreement.
Okay. Enduring power of attorney, the distinction between a regular power of attorney and an enduring power of attorney is an enduring power of attorney works when someone has an incapacity and unable to manage their own financial affairs.
It's financial affairs.
Financial affairs. Power of attorneys are only for financial affairs. Representation agreement deals with health care decisions, and it only deals with health care decisions and helps communicate what the person's wishes are if they're able to communicate.
So if I'm in a coma that I'm not likely to recover from, you can pull the plug.
If that's what your representation agrees. Now, so long as you have your capacity, you're in charge and you can make your medical decision. It's when you're no longer able to express your wishes for health care that the representation agreement would apply.
Okay, in signing off, I'm just going to say that if you're out there, you want to stop procrastinating, you want to get your future going today, you do this by making a phone call. Frida down at the office, she's there right now, area code 604-737-3512. If you're over on the island or long distance, it's 800-661-1495. I'd like to thank Alfred for being here today. Alfred, your stats are on the screen. Everybody's probably been looking at that. But what's your phone number in case anybody wants to talk to you?
604-642-5696.
So let's thank Alfred for being here. And again, I will remind you once again to listen tomorrow between 10 and 11, and you can get a nice replay of this show. Bye for now. See you same time, same station next week.
If you'd like Fred to review your portfolio, call his office right now at 604-737-3512. That's 604-737-3512.